All right, what we're trying to do here is go into a little bit more detail on our protected subjects. And it's a safe bet that PR is going to be on there. This time it could be in the form of a crossover. Now, so be alert to that. Be alert to a crossover. If it is a crossover, you'll want to earmark at least the last 15 minutes to answer it. And the reason is it's going to be important, and they're going to really be wanting to make sure that you understand the rules of professional responsibility. Now, pursuant to that, for a crossover or for a full-blown PR, here's something I'd like you to think about. Now, it turns out that if you simply respond to the specific rules, like you give lip service to the rule, you see a rule, it might be violated, you write the rule down, the attorney didn't do it right, the attorney violated his ethical duty. That's what I call lip service. And I can assure you that those do not get good scores. And a lot of people say, well, why didn't I get a good score in PR? Or even, how did I get such a bad score? I thought I knew PR. And the answer is, in my personal experience, California bar examiners grade PR more stringently than any other subject. The other one that gets graded stringently is community property, which is why I spent some time on it for you. With that in mind, I think we need to step back and think of a better approach, a better way to think about this, and a better way to write it down. And here it is. You see, the basic ethical principles, all of the ethical principles, not only for law, but for psychology and medicine and social work, underlying these basic ethical principles are even broader principles. The principle of honesty, the principle of integrity, the principle of loyalty, and the principle of due care. And here's what I want you to do. When you see the attorney acting, I want you to think, well, what is the underlying ethical issue? Honesty, integrity, loyalty, due care. Example. Let's say they say the attorney's client is thinking about perjuring himself, and the attorney himself misrepresented who he was to a represented party and interviewed the represented party without telling opposing counsel. Did the attorney violate his ethical duties? And I don't want you to think about this as, well, what are the isolated rules? I want you to think, what is the overarching ethical principle involved? And think about it for a moment, and the answer should come to you quickly. Choose between honesty, integrity, loyalty, and due care. And I think you're going to see that honesty is implicated here. So here's what I want you to do. Begin by head-noting honesty. And put down the general rule, which is a rule that attorneys have a duty of honesty in all circumstances, whether connected with the practice of law or not. And then analyze your facts to show that honesty is implicated. That's all I want you to do. Show that honesty is implicated. So what you can say is, when the attorney misled a represented party, that implicated that attorney's honesty. All right, now you set the stage. And now what we could do is deal with each of the specific rules that might be violated, and we can deal with them all at once instead of scattering it around and giving lip service. So as an example of the attorney's honesty or problems with honesty, we have the issue of duty of candor to the tribunal, which goes to the potential perjury, and then you discuss. And we also have the rule that says that an attorney shall not interview or deal with a represented party without getting permission from opposing counsel. And then we analyze that. In our case, the attorney did blah, 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 and that appears to be violating this ethical duty. And then another one that goes to honesty, and that would be that the attorney has a duty of honesty to third parties. In this case, the represented party could be considered a third party, or maybe the attorney got involved in misleading a third party. In any case, you want to take everything that goes to honesty, take it all at once, and deal with it in a cohesive manner. Now, we recognize this in our Power Law program because under PR, we actually have two outlines. One outline just gives you the ABA rules and California distinctions in order of the ABA rules. So we take the ABA rules in order by number and then give you the California distinction after that. However, we have a second independent outline that lists the basic core ethics: honesty, integrity, loyalty, and due care, and then tells you the specific rules, with an emphasis on California law, by the way, tells you the specific rules that are implicated under each of these categories, so that we would have all of the rules pertaining to honesty organized in one place and so on. I think this is a much, much better way to approach PR, a much, much better way to think about PR problems, and a more effective way to communicate rather than giving lip service. All right, now, what you want to do is study past patterns. I've said that repeatedly, and it's not going to change because there's a substantial body of research demonstrating that the road to expertise is to study key patterns and to get those key patterns into your memory, and not just memorize, but to learn. And so I want you to study as many past models as you can and find a way to group them. I'll give you an example of the way I would group them. I group them in terms of, do they go to a corporate setting? And if I were you, I'd study 2-3 models of an attorney ethical principles in a corporate setting. There are several out there. The California Bar tests the corporate setting a lot. There's also patterns in a criminal setting. Those are fewer. And generally when you get a criminal setting, it's going to be crossed over. PR will be crossed over with criminal law. And then you have your private practice settings. And if it's a private practice setting, I've got to tell you, the issue of a concurrent conflict of interest seems to be one of the biggest. So if I were taking the bar, I would definitely memorize the whole rule on concurrent conflict of interest, and it would be one of the first things I'd want to think about: is there a concurrent conflict of interest going on in my hypothetical? Because I think that you could write about it and could have written about it in 8 out of 10, if not 9 out of 10 of the full-blown, and at least 50-60% of the crossovers. So that's my advice in professional responsibility. It's going to be on the bar. You know it's going to be on the bar, so make sure you study it well.